The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention to the court is now sitting. God save the United States and this honorable court.
Thank you. Good morning. You may be seated. All right. Good morning again. We have two cases today. The first case is number 244502, United States versus Tremaine Hawkins. And we have Mr. Walker, and then also Mr. Reed. All right, thank you. All right, yes, sir, Mr. Walker, we'll be glad to hear from you.
May it please the court?
Yes, sir.
Good morning.
Good morning.
Mr. Hawkins should prevail because there was no context, no action, and no behavior supportive of reasonable suspicion of drug activity in his case sufficient to prolong the traffic stop that he suffered. I'll start with the action, and I think everyone is probably waiting to talk about the so-called, or ask questions about the so-called hand-to-hand transaction in this case. I want to point out right up front that the interaction between the gentleman in the parking lot that was under surveillance in this case, Eagle Court apartment complex. There was a Jackie Bird that approached Cornelius Johnson's car, and Jackie Bird had a conversation, spoke to the occupants of the vehicle. He didn't engage in a hand-to-hand transaction. It's a hand-to-hand transaction in this case, in name only. And I'd like to explain to the court why. Number one, the officer...
Actually, do they even see their hands?
No. But more importantly, just like the Drakeford case, I mean, I don't think this court has to go far beyond Drakeford in order to rule in favor of Mr. Hawkins. The officer who conducted surveillance, he didn't see an item in any hand. He didn't see cash in any hand. He didn't see any other behavior during this so-called hand-to-hand transaction that was indicative of drug use or a drug transaction. And of course, it's so important to point out when we talk about context that just like in the Drakeford case, this happened in broad daylight. This happened in the middle of a large parking lot where people are coming and going from all the apartments in the area. And also, I think what undercuts this idea that it was a so-called hand-to-hand drug transaction, of course we know it wasn't because there were no drugs ever found, but what undercuts the claim is that Jackie Bird remained at the vehicle for, I think, 2 minutes. So that looks more like a greeting, looks more like a casual conversation, that looks more like people who happen to know each other, which in this case they did. They were
let's
relatives.
Stop right there
Yes,
just a
Judge.
minute.
Yes, Judge.
Let's just say, I mean, what are we evaluating? Are we evaluating that action, or are we evaluating what the officer who made the stop relied on? He says there was a transmission from that guy, right or wrong, to him, that we think there was suspicious drug activity, and if you can stop him, stop him. How much reliance can that second officer give to what the first officer?
It's a tip. It's a reliable tip. Just like in the Critchfield case, I was here a couple of years ago, and there was a postal inspector observing certain conduct that was occurring in the community. That postal inspector...
So where does that fall on the sliding scale of probable cause?
Well, probable cause is really not in play. In this case, it's reasonable suspicion. But I think that Officer Stanley was permitted to accept this statement from Detective Burke for what it was, that it may have been a hand-to-hand. Officer Burke said he believed there was a hand-to-hand. Officer Stanley can take that into consideration. But a so-called hand-to-hand transaction, just like in Drakeford, even if we take at face value what Burke said, is not sufficient, because sometimes a hand-to-hand, like in the Drakeford case, is just a handshake. So this court other panels of this court, other published opinions of this court require more than people touching hands or people getting close enough where they potentially could exchange some kind of item. So just like in Drakeford, that alone is not enough.
So
And-
if we accept your argument, then we don't have to get into the idea, we don't have to get into the time clock, whether it's 15 minutes, 30 minutes. The case just ends on your argument that there wasn't enough activity to create a suspicion of a drug activity.
Correct.
Let's
That
just-
hand-to-hand alone is certainly not enough. Now, I will
But
concede.
don't we still have to consider the clock? Because even if that's not enough, then we're just looking at the traffic stop itself on the basis of the tail light or the illegal turn, whatever that they
Oh,
saw.
Well, here's my response. My response to the clock question is very simple. This is unlike many cases where an officer addresses the mission of the stop, let's say the traffic violation, and then elects to extend the stop beyond that necessary time frame. Because in this case, Officer Stanley, he didn't take a detour. Sometimes we have cases where the court talks about an officer taking a detour into another investigation. Officer Stanley completely disregarded the original mission of the traffic stop, which was the moving violation.
But he informed them of the moving in violation.
He told them why he pulled them over, but then he almost immediately began his drug investigation. And the best place to see that is the video in this case, because you can see Officer Stanley takes Mr. Williams out of the car, asks him questions related to the drug investigation. This is all before he issued any kind of warning to Cornelius Johnson for the traffic violation. Then he has Mr. Johnson get out of the car and ask Mr. Johnson for about 5 minutes on the side of the road. It's all on the dash cam. Questions about the drug investigation. So you can see, based on the video and based on the testimony, Officer Stanley skipped the investigation that related to the traffic violation, and he nearly immediately began to engage in a drug investigation without reasonable suspicion to do so. So in terms of time, this is really a de minimis case. This is a case where Officer Stanley began to prolong the stop without reasonable suspicion. He didn't do it for hours. It wasn't 50 minutes or an hour and a half. The whole thing just took about 28 minutes. But he did it when he started the drug investigation and nearly disregarded the investigation relating to the traffic violation.
How much weight do we give to his testimony then, that he never gives tickets for that kind of activity?
Do you believe that?
No, well,
Do you?
I thought that's favorable to you. He's holding them there.
Nobody in this courtroom believes that a patrol officer in Wheeling, West Virginia, who's been doing the work for 6 years now, +2 since the traffic stop, never gives someone a ticket for a traffic violation. Nobody believes that. No one could believe that. And I challenge my friend on the other side of the V to come up here and tell me that he believes that Officer Stanley never gives anyone a ticket for a traffic violation.
Well,
what does he do for his job?
You're missing the point. I'm trying to help you here.
Well, but it is what it is. I mean,
okay,
he's not credible.
So it is, but that's what he said.
Right.
Now, if that were true, why would he be holding them 28 minutes if he wasn't going to give them a ticket in the first place?
That's absolutely right. I can't answer that. I mean, how do you answer a question that's sort of false, has this false premise, right? The bottom line is he had no reason to conduct a drug investigation, and he did. And now the government will argue that, well, Cornelius Johnson was a known drug dealer. In 2014, I mean, at what point is a conviction stale? And I think it's very telling. Very telling.
Well, I think Drakeford is going to handle that for you. I don't think you need to.
Right.
Drakeford says
Sure.
we can't.
You can't.
view it
None
through
of the cases.
Yes, based on it being unknown.
Yeah, the cases don't allow us to reach back that far to find relevance to a conviction. But it's also very telling in this case, which I think is different than Drakeford, that Mr. Johnson was on federal supervised release at the time of the traffic stop, and I think the evidence is, at least the record is, I think, clear that he didn't violate his supervised release. So the system actually worked. The system is designed to rehabilitate people. Cornelius Johnson was rehabilitated. He was on federal supervised release. He was working. He had never violated his supervised release. He wasn't involved in any crime, and we know that because he didn't violate. So the fact that Cornelius Johnson had this prior, again, is sort of Detective Burke, as we say in Bush, Virginia, bless his heart. I mean, he's trying to do his work. He's trying to be a drug task force officer. He's trying to be effective. But he had, sort of this bias coming into this situation. He just presumed that Cornelius Johnson was up to no good. He followed him all through town. He presumed that this was a hand-to-hand when there was no evidence that it was a hand-to-hand. That's really what we're left with. I want to point out, I think this is really, it's in broad daylight. We talked about that. There's no informant. Even in Drakeford's case, there was an informant who said, that man over there, he's a big drug dealer. We didn't even have that. We didn't have that kind of context. There was no 911 call, no complaint. We don't even have like the typical, we had been receiving a lot of calls from Eagle Court that month, a lot of complaints in Eagle Court that month about drug activity. I mean, Eagle Court was just sort of neutral. It wasn't a hot spot. I think that's a very important point, that Eagle Court was not a high crime area. And again, happened in the middle of the day. There's one other point that I would like to make about the so-called inconsistent statements.
Yeah, let me ask you, I was going to ask you about that because of course, I think the government, and we'll hear from the government, is saying, well, there's this inconsistent statement. I think the question was, did you meet anyone at the apartment? And there are two different answers. And so I'm curious to hear your position regarding that as to, if we look at the totality of the circumstances and that, because there's two different answers, then we are in a position of inconsistent statements and reasonable suspicion.
Right. We have to analyze that. And what I wanted to tell the court is that the inconsistent statements occurred after the drug investigation began. So they could never be a basic so-called inconsistent statements. They weren't inconsistent statements. But whatever, if you want to call them inconsistent statements, they occurred after the drug investigation began. So the violation of Mr. Hawkins' Fourth Amendment rights occurred prior to the receipt of that information. The government can never rely on the so-called inconsistent statements as a basis for Officer Stanley to conduct a drug investigation, because Officer Stanley was conducting the drug investigation before he received the so-called inconsistent statements. But just assuming for a minute that the government will argue that look, this was all evolving, it was all sort of in real time, and it's hard to say when the drug investigation.
So it's your position that you can't add on to the totality of the circumstances once the investigation has started?
It was too late. The government, Officer Stanley was required to have reasonable suspicion to conduct a drug investigation before he conducted the drug investigation, because it was the drug investigation that prolonged the stop. So we can't take what happened after he began the drug investigation to support the drug investigation itself. But however you look at it, the statements weren't, and I know that's not really laid out clearly in the briefs, but if you look at the video and you look at the chronology of it, the inconsistent statements came after the violation. But they were not inconsistent statements, not at all. Williams and Johnson both admitted to being at Eagle Court. They both admitted that they had an interaction with another person. Now we know Jackie Bird. And they both admitted to having a conversation with Jackie Bird. The particulars were reported differently to Officer Stanley. But again, Officer Stanley said, what happened at Eagle Court? And that's kind of a general question. So you can get two different responses to a very general question, and both can be true. It can be true that Jackie Bird wanted a cigarette. It can also be true that Jackie Bird wanted to talk to Cornelius Johnson about a job. And those were the two explanations that were given. So while the particulars may be different, the statements are not in conflict. They are not mutually exclusive. And I will like to note, I just have another minute left, that and I can't put my finger on the name of the case, but there are cases, published cases from this court, where there are true inconsistent statements, and it's very valid in terms of supporting reasonable suspicion. But what we're seeing is one occupant of a car saying, "Oh, we didn't go to Greenville, South Carolina." The other occupant of the car said, "Well, we just came from Greenville, South Carolina." That's very helpful information. You know someone is lying under those circumstances, and that's, again, somewhat of a extrapolation from the cases, but we see cases where occupants are saying things that cannot coexist as two true statements. But that is absolutely not what happened in this case. Both of these gentlemen were telling the truth. They just had different recollections of what happened on Eagle Court. And I mean, again, sort of for crying out loud, just to be a little colloquial here, both men said they knew Jackie Bird. Both men said they saw Jackie Bird. Both men said Jackie Bird came up to the car. I mean, what more do you want from them on the roadside when they're sort of pulled over? They don't know why they're pulled over. They're potentially nervous. They gave answers that were totally satisfactory. And again, Officer Stanley is...
All right, thank you, and I think you've reserved some time.
Oh, thanks very much. I hope that answers your question, Your Honor.
All right, thank you. Yes, sir. Ms. Reed.
Good morning, Your Honors. May it please the court. My name's Clayton Reed, and I represent the United States in this matter. Your Honors, the totality of the circumstances established Officer Stanley had reasonable suspicion that justified any extension of the stop. And for those reasons, the district court properly denied his motion to suppress, and their judgment should be affirmed. I'd like to start with, there was a lot of talk about Drakeford, so I'd like to start there. Drakeford, Mr. Hawkins relies on Drakeford. The only sort of consistency or fact that is somewhat close is this handshake interaction. But the distinctions are, there were several things that were relied on in Drakeford that are not here, that were differences. They had general information from a confidential informant that the court found there was scant information about that CI's reliability. There was 2 interactions they thought were consistent with drug transactions, and then no drugs were any found. And then we had this handshake exchange that was believed to be a drug transaction, even though the officer said they did not see anything that was actually exchanged. But even that is different in this case, and because in that case, we knew there was a handshake. The officers testified to it, they saw it. The only parallel Mr. Hawkins draws here to this being a handshake is because he says it was a handshake. That's what they want the court to believe.
Well, isn't that the
happened in
problem? We don't know what happened when he reached into the car. You can't even say that their hands touched. There's nothing that they observed.
In that way, it's similar, Your Honor, in that they did not observe anything change hands. But
It seems as if you may have had, these officers had less than the officers had in
Yes.
Drakeford.
well, I think what's also different, Your Honor, is that in Drakeford, the court found that the officers overlooked a lot of things that could have diminished the reasonable suspicion inquiry or the.
Well, what about Mr. Byrd? I mean, they had an opportunity to speak to Mr. Byrd, right?
They did, Your Honor, and
If we're
Officer.
talking about overlooking, I mean, it just seems like that there's less here than the officers said they had in Drakeford.
I think there's vast distinctions between where this took place and what the officers observed and what they did in Drakeford. Because in Drakeford, it was a very public place.
Isn't this a parking lot?
It's a parking lot, Your Honor, in a apartment complex that's kind of
And
secluded, but
it's in daylight.
yes, Your Honor, that's the same. But this was inside a vehicle. In Drakeford, the officer testified how these drug deals usually would go down is people would get into vehicles, exchange drugs. That's what happened here. There was a vehicle involved where you didn't see what actually happened. In Drakeford, it was outside of the vehicle, which the court said that didn't support what the officer had testified you would expect to see in a drug transaction. And then they all went together into a store and began shopping immediately afterwards. Now, Mr. Hawkins was there for a minute or two, but he then left. So the facts and sort of the,
He was picked up, correct? Isn't
I'm
that-
sorry, not Mr. Hawkins, Mr. Byrd left
Okay.
after this transaction, Your Honor. And it's also different in Drakeford that the officers knew in that case that the individual they were surveilling had some arrests before for drug trafficking. They did not know that anything about whether those arrests led to convictions. Where here they did know that there was convictions. They knew the circumstances of that underlying
But why
case.
does that matter when they are so long ago? Because
It's-
what does this mean for people who have past convictions? That every time they go about their ordinary life, then they are somehow more suspicious than other individuals?
Of course not, Your Honor. It's just a factor in this list of factors that goes into it. If all they knew, because that's not what happened. They did not just see Mr. Johnson and say, okay, we know he was previously convicted. Let's stop and see what's going on.
But
with
that's
him."
what made them start following him, from the first location to the second location.
That, in addition to where they observed him originally, they observed him in an area that they were conducting surveillance because they had drug investigations in that area. So those
Is
two
this a
things
part of
can.
town? Is this just a part of town where,
It was a specific, the 400 block of, I think it was Ontario Street in North Wheeling Island, Your Honor, and Officer Burke testified that he had investigations in that specific block and that they often conduct surveillance in that area because of all of these ongoing investigations in that area, that they could check on different things and sort of, over time, continue to build their investigations. But I'd also like to talk about, Mr. Walker said that Officer Stanley completely disregarded the traffic violation, and that is clear from the video. And I would completely disagree with that. If we watch the video from the traffic stop, Officer Stanley is diligently pursuing both the traffic stop for traffic violations and his drug investigation. He approaches the car, within 30 seconds of stopping it. He collects the information of the driver, information on the passengers. He goes back to his car. He calls dispatch with that information. As he's awaiting for dispatch to get back to him, that's when he begins, once he has some backup, because there's 3 individuals in the car, once some other officers arrive, that's when he starts talking to him.
But doesn't Stanley testify at a district court that he was always investigating them for the drug activity?
I believe he did, Your Honor, and he certainly had that also in the back of his mind, right? But to say that if the court doesn't, so the district court, I think, found that Officer Stanley's possessed reasonable suspicion at the time he stopped the car. And so therefore, any extension past that time was okay because he had reasonable suspicion. If the court doesn't accept that fact, then I think you do have to, as you alluded to, Judge Giles, talk about, well, was he pursuing the traffic stop as well, and when was there actual extension of that traffic stop, if we're just looking at it based on a traffic stop?
So what did he learn when he went to the patrol car and called in the information? What added to the scenario that would cause him to get out of that car and come back? This is a routine traffic stop. Is there something that he was told from dispatch that would cause him to get them out of the car? Because this is just a traffic stop.
He was pursuing his drug investigation at that point, Your Honor, but the stop had not been extended at that point. If you watch the video, it's at the 9:44 mark into the video that dispatch calls him back and tells him that the occupants of that vehicle don't have warrants, everything's valid. So if this were a straight traffic stop, that would be the point in time that he could have concluded that traffic stop, that he could have let everyone go.
And so did that occur before he got them out of the car or after?
That occurred it was in between talking to Mr. Johnson and talking to Mr. Williams and Mr. Johnson. So he had already talked to Mr. Williams. He had already been lied to.
Mr. Williams is the driver?
Mr. Johnson was the driver, Your Honor.
So why do we talk to Mr. Williams when Mr. Johnson is the driver?
Well, he had originally talked to Mr. Johnson when he stopped the car, when he's collecting information, where are you coming from? But as he's awaiting confirmation on valid license, if anyone has warrants, Then he's following up, he's diligently pursuing both at that point, I would argue, his drug investigation and his traffic stop, which is still ongoing. And so when he talked to Mr. Williams, by the time he could have even stopped that traffic stop and learned that he could have let that car go because no one had any warrants, he had already been lied to by Mr. Williams. Mr. Williams was asked, did you meet anyone at North Park? And he said no.
Well, who did he meet?
They met Mr. Bird. He didn't mention Mr. Bird.
But Mr. Bird walked up to the car. I don't know if, how do you characterize that as him meeting, that he went there to meet Mr. Bird? How is that a lie?
Your Honor,
It wasn't, the question was, did you speak to someone at the apartments? The question wasn't, who was it that came up to your car? If he had said, oh, no one came up to the car, that might be a lie. But it was just an open, and they're in the parking lot of the apartment. Who did you meet at the apartment? He didn't even go in the apartment. So how is that a lie?
I think what is relevant, Your Honor, is what the district court pointed out, was that it was reasonable for Officer Stanley in that situation to perceive that he was receiving contradictory information and lies.
Okay,
because
back to,
he
okay,
didn't mention
back
Mr.
to that. So the issue, but then once he says, who was the guy that came to the car, he said, oh yeah, that was Mr. Bird. He came and asked me for a cigarette, right?
Yes, Your Honor.
Okay, so I guess my problem is it's the question that you asked, right? And the question that he asked was broad and open-ended. So I could ask you, you know, how was the weather outside when you walked in today? You might say it was windy. Mr. Walker might say it was sunny. Could there not be both? Can it not be windy and sunny? Is that a lie? Just because both of you gave two different answers?
No, Your Honor, but I think the question was more direct than that.
But if the question was, if I said the question was, was it cloudy outside, and one of you said, no, it was sunny, and the other one said it was rainy, then that would be inconsistent. But I think what you all are saying is inconsistent, or what the officers are saying is inconsistent to a very broad and open-ended question, is not inconsistent. It's just different. Both could be true. He may have asked one person for a cigarette and the other one for a job.
When we're talking, Your Honor, when we're talking about what answers both individuals gave, I think both could be true. But what is important is, as the district court found, it was reasonable for him to believe that those were inconsistent. And before that even happened, that he was, I think, asked a more direct question of, did you meet anyone up there? And he said no. He didn't mention Mr. Bird. He didn't even mention picking up Mr. Hawkins.
It was phrased as who you met. And to the point, I mean, that is, when you're meeting someone, that's not someone just walking up to a car. You know, that's implies something more than something passing. And so the response is not something that would be inconsistent or make it seem like he is trying to hide something.
Your Honor, I believe the original question was, did you meet anyone up there? And it was no. And then he said, what about the guy in the red jacket? Because he knew that was not true. And so then he was allowed to sort of elaborate, yes, he just wanted to bum a cigarette. But I don't think it was unreasonable to believe that when he didn't mention either Mr. Bird or Mr. Hawkins, to believe that he was trying to conceal that they met with anyone. And then later when he received conflicting stories, to believe that those were conflicting, even though both may have been true. I think the germane question is, was it reasonable to, in his mind at that time, to believe that they were conflicting based on what he was faced with? And so to Mr. Walker's point, Your Honor, that, again, if the district court found that Officer Stanley had reasonable suspicion at the very initiation of the traffic stop, if the court doesn't agree with that, by the time that the stop would have been extended at all, by the time that he could have gave that warning and let the car go, he had already had the initial conversation with Mr. Williams, and immediately after that had the conversation with Mr. Johnson. So he had that additional factor of what he was hearing from these individuals. And I don't think, so Mr. Walker's points that these statements occurred after the drug investigation began, I don't disagree in that he is conducting a drug investigation that entire time, but it's not at a point after which he extended the traffic stop. The traffic stop was still ongoing when this additional factor came into play. So that those statements would factor into, if the court doesn't believe that reasonable suspicion, he had it at the very beginning of the stop, whether he could then at that point extend the stop.
What concerns me a little bit is, how does a traffic stop end?
How does it end, Your Honor?
Yeah.
Normally, either with a citation or a warning, or however that officer is going to conclude that
And you're
violation.
suggesting to us that it took 28 minutes to conclude a traffic stop.
I'm not, Your Honor. I'm suggesting the earliest point in time that he could have concluded that traffic stop was about 8 minutes and 44 seconds into the stop. It was the time right after he had the discussion with Mr. Williams, right before he had the discussion with Mr. Johnson, that he was told, it's just dash cam video, so we can't see everything, right? But we can see what's happening, and all we can hear is, if anyone's in the car, we can hear it, and we can hear the radio traffic. And what we hear over the radio traffic is dispatch come back and say negative NCIC, meaning they don't have warrants. That's the point where he's concluded his license checks, his checks for warrants. That's the point. The earliest point that he could have walked up to the car and given the warning and let them go. But at that point, he had everything that was going into the traffic stop and what he had developed during that stop. And so it's at that point that if there was an extension that's impermissible, that the court would have to consider what he had at that time. And at that time, he had the additional factors of talking to those individuals.
What about this, I mean, Judge Floyd brought up earlier that he said he never gives traffic violations for the traffic stop. I mean, so what's the purpose of the traffic stop?
I'm sorry, Your Honor, could you?
He says, I think it's on JA 97, he said, I usually don't ticket for traffic violations.
I think and just said he usually gives a verbal warning.
Yes, so what was the purpose of any of it other than just saying, hey, your light's out in the back? Of asking questions of everyone in the car, and if he's just gonna give them a warning that the light's out in the back of the car, what was the purpose of anything beyond that?
He said, Your Honor, he was also investigating suspected drug crimes based on what he was told.
But so then that takes us back to what Mr. Walker says regarding reasonable suspicion as to the investigation of the drug crimes, right?
As to the investigation of the drug crimes,
What
if he was
the reason-
delaying this
Yes.
traffic stop, just to investigate drug crimes, just to wait on a K-9, then that is something that we would consider. My argument is he was not delaying the traffic stop at all. He was diligently pursuing both. And by the time he ever got to the point that he could complete that traffic stop, give his warning, and let them go, he already had the conversation with the two individuals. And it's at that point where he felt he was lied to, where he felt he was given conflicting stories, that's the time that he called the K-9. That's the point he made the decision, he first asked the quickest way that he could sort of dispel or confirm his suspicions, which was consent. That was denied. The second fastest way he could do that was to get a K-9 there.
So, I'm sorry.
No, go ahead.
So, let me back up to your 8 minutes. You got me confused now. You said that at the 8-minute mark, he could have concluded the traffic stop if he had wanted to. We know that he'd already talked to at least one of the individuals. I don't know whether he talked to the second. So what did he do after 8 minutes other than sit around and wait?
He was, I think that's not uncommon, Your Honor, waiting to hear back as far as information on who's in the vehicle. That was occurring, and while he's doing that, rather than just
No,
waiting.
you told me at the 8-minute mark, he had gotten the all clear on any warrants, et cetera, and he could have concluded the traffic stop at that point. So what did he do after 8 minutes to investigate?
He got that confirmation after he talked to Mr. Williams. Mr. Johnson was on his way out of the car when that comes through the radio. After that point, he talked to Mr. Johnson briefly for a couple minutes and called a K-9 after 2 or 3 minutes, after he was denied consent. So I guess my point being, Your Honor, that he wasn't just sitting around, he wasn't delaying anything to call him the K-9. He hadn't even called a K-9 at that point. I think he was doing what we want police officers to do, is ask questions, see if he can alleviate his concerns before.
Well, let's continue your timeline. You said 8 minutes, and it took 2 more minutes to deal with the next individual. That's 10 minutes. So at what point after that did he call the K-9?
He called the K-9, so he received the information about the warrants at the 9:44 mark of the traffic stop video, Your Honor. He called to request the K-9 at the 12:26 mark. So 2.5 minutes. And that is while he's conducting the conversation with Mr. Johnson. And I see that I'm out of time, Your Honors, unless you all have any other questions.
Any other questions? All right, thank you, sir. Yes, sir, Mr. Walker.
Thanks very much. I'd just like to read one paragraph from United States versus Foster, 634 F3rd 243, 2011 case. This court wrote, we're deeply troubled by the way in which the government attempts to spin these largely mundane acts into a web of deception. Although these matters generally only come before the court where a police officer uncovers some wrongdoing, we would be remiss if we did not acknowledge that the exclusionary rule is our sole mission of ensuring the police refrain from engaging in the unwarranted harassment or unlawful seizure of anyone, whether he or she is one of the most affluent or the most vulnerable members of our community. Unless this court has any questions, I have nothing further.
No questions.
All right, thank you.
Thank you very much.
All right, we will, just Giles and I will come down and shake your hand, and if you all, would walk up and shake Judge Floyd's hand. Be seated, and we're ready for our next case, American Acceptance Corporation of South Carolina versus John Geitz, and that's number 251448. And I didn't ask, no one needed a break, right? No break.
What'd you say?
You didn't need a break.
No,
Okay.
I'm a giddy up the other day.
All right, first we will hear from Mr. Studemeyer on behalf of American Acceptance.
Yes, In 1972, in Fuentes versus Chevin, the Supreme Court observed that for more than a century, the central meaning of procedural due process had been clear. Parties whose rights are affected are entitled to be heard. And in order to enjoy that right, they must first receive notice. 27 years later, in City of West Covina versus Perkins, the Supreme Court held that when law enforcement seizes property as evidence in a criminal investigation, law enforcement must take reasonable steps to give notice that the seizures has occurred so that parties with interest in that property might pursue its return. 23 years after that, the appellees seized 2 motorcycles in which my client holds recorded security interests. The appellees took no steps to inform my client that the seizures had occurred. The appellees took no steps to give my client an opportunity to be heard. Even worse, the appellees threatened my client with sanctions simply for seeking an opportunity to be heard. Our case is simple. We ask for nothing more than what is already required by the Supreme Court's holdings in Fuentes and Perkins. In the district court's order granting the appellee's motion to dismiss for failure to state a claim, the district court held that as secured creditors, yes, we were entitled to notice and an opportunity to be heard following the seizures. They held, on page 2 of the order, that no, we were not provided with notice of the seizures. They never held that we were provided an opportunity to be heard.
Counselor, I want to go back to Perkins because I know you rely on it.
Yes,
But
ma'am.
in Perkins, it concerned due process after the state no longer has a lawful right to retain the property. And so isn't that what puts this in a different position here?
Well-
Because this was an ongoing criminal investigation and prosecution?
Oh, Your Honor, in Perkins, the notice was given at the time of seizure. Notice of
It
seizure.
was notice, it was a search warrant inventory, correct?
In Perkins, yes, Your
Yes.
Honor.
And that's usually given to the person whom the property is seized from, not necessarily the person who has a third-party interest in the property.
Yes, Your Honor.
So
but in-
isn't that different?
Well, in our case, one item was seized pursuant to warrant, and one item was seized pursuant to an exception to the warrant requirement.
Yes.
But the timing of the seizure there, I think, is important. The holding in Perkins is that law enforcement must take reasonable steps to give notice, and their reasonable steps were considered leaving the inventory, the warrant at the
But to
scene.
whom did they leave the inventory? That's the thing, because we're talking here about a third-party interest in the property, as opposed to the person or individual who also has a property right as well, but it's also the individual from whom the property was seized.
Yes, Your Honor. And in Perkins, the seizure occurred at the home of a family with whom the defendant was, in that case, was living. So I'm not sure that the police knew whose property they had following that search warrant. I don't think they knew if it was the person from whom they were actually seeking the property or if it was the family.
Well, they would have been looking for something in particular, because it would have been the bike who the person that they were investigating for the murder was driving. And so there would be a basis to know that that was his bike that he was driving.
Yes, Your Honor. But the reason that the notice must be given is so that an opportunity to be heard may be had. And the opportunity to be heard, as the court in Fuentes states, is merely provided to prevent mistaken or substantively unfair deprivations.
But Fuentes also says unless there's these exceptions, unless there's some valid governmental interest, and I'm sure counsel we know on the other side is gonna say that the valid governmental interest is that they're investigating a murder and motorcycles that were involved in a murder. And so why would that not be a valid governmental interest under Fuentes?
Your Honor, if I understand your question,
It wouldn't, I guess what I'm saying is that there's a valid governmental interest here, right?
yes, Your
You're
Honor.
citing Fuentes, but you didn't say the second part, and except in extraordinary circumstances if there's a valid governmental interest, which it appears that there was a governmental interest, a valid governmental interest here in retaining the motorcycles.
Yes, Your Honor, but retaining without notice that the seizure had occurred, I don't believe that's what Fuentes stands for. I think the opportunity to be heard is just to ensure that there is no mistaken or substantively unfair deprivation. So, of course, law enforcement is entitled to deference. Of course, law enforcement must be given the tools that they need to conduct criminal investigations. But I don't believe that Fuentes or Perkins gives law enforcement carte blanche without some informed, neutral evaluator to retain property as evidence for the duration of a criminal investigation.
So why don't we get rid of this case under qualified immunity in as much as there's no clearly established rule that I could find that says exactly when you have to give you notice when the criminal proceedings are completed. And so you sue these officers individually, some of these people individually. Why doesn't qualified immunity get rid of it? Or if that's not good enough, how about TransUnion or the informational injury which you claim you didn't get notice? What is the in order to recover under that TransUnion theory? You would have to have suffered some injury. So, first of all, how about the qualified immunity argument? Second, if that doesn't work in TransUnion, what's your damage? You got the motorcycles back.
Well, Your Honor, we don't have the motorcycles back at this point.
But you could go get them anytime you want. You got them. You got constructive control over those motorcycles. All you got to do is go ahead and get them.
Well, and we're not aware if the motorcycles are operable, but yes, Your Honor, we
Well,
could
that doesn't count in the equation. Surely, the battery might be dead. You've been sitting around for ever how long, waiting on this case.
Yes, Your Honor.
They don't have to deliver it to you in perfect shape. They just have to deliver it to you the way they got them.
Yes, Your Honor. So first, on the qualified
Yes,
immunity issue. Qualified immunity, I don't believe protects here law enforcement, simply because,
You sued under 1983.
yes, because we believe it's their suit or practice to refuse to tell any party that they have their property until they've deemed it no longer necessary for criminal investigation.
But what is the clearly established law that says when they have to do that?
Well, and we believe that comes from Perkins. It says that law enforcement must take reasonable steps to provide notice. Reasonable steps necessarily incorporate some analysis of timing, that the right steps at the wrong time are no longer reasonable.
So how long have you been aware that you could go get these motorcycles anytime you wanted?
We were offered the motorcycles, I believe in the, I don't remember with
Was it
certainty, Your Honor.
October?
October of
Or
last year,
20, yes.
something like that. So 2 years following seizure.
2 years?
Yes, sir.
And you filed a suit in 25. Or this appeal was
This-
filed in
yes, sir,
25.
this
When was
appeal.
your suit filed?
Our suit was filed in 2023.
This suit, but you also had a suit in state court.
Yes, Your Honor. We initially filed suit in state court for claim and delivery. We were simply seeking some way to get an opportunity to be heard. And we thought that was the most apt mechanism
And so that was due process, right?
that we
That suit,
initiated a lawsuit for claim and delivery.
that was your opportunity to be heard on that, correct?
Well, I don't believe that counts as an opportunity to be heard because we were never heard on the merits of law enforcement retaining the property. That the court didn't have to reach that question. The court held that that law enforcement pardon me, Your Honor, got a little flustered up here.
Oh, that's.
No, but the claim and delivery initially before the state court was dismissed with leave to refile because you all served, because the statute says you have to serve the Attorney General and you served the Sheriff's Department. And then you all refiled the claim and delivery, added a 1983 claim. And then that's when it was removed to federal court.
Yes,
Right.
Your Honor. Yes, yeah, we were content for this to be a state law claim. We think this is something that should have been handled in South Carolina because If this seizure had occurred 90 miles north, there's a clear statutory process for the sort of claim we're making in North Carolina General Statute 15-11.1A.
Who removed it to federal court?
The appellees removed this to federal court.
Well, that's, I'm assuming that's because of the 1983 action.
Yes, Your Honor. Yeah, so to go back to that North Carolina statute, South Carolina doesn't have anything analogous to Rule 41G of the Federal Rules of Criminal Procedure. We don't have any way to seek the return of property seized as evidence. We don't have anything analogous to North Carolina General Statute 15-11.1A. And I believe we're the only state in the Fourth Circuit that doesn't have some mechanism to allow parties with interest in property to seek its return. You know, the other states in the Fourth Circuit allow a judge to weigh in, or just an informed neutral evaluator. And that's all we sought. That's all we're seeking with this, is some mechanism to know where our property in which we have interest is during a criminal investigation and ask us if its retention is necessary. And at present, it doesn't appear that there is one in South Carolina, and it appears South Carolina has been aware of this since at least 1998, when our Attorney General signed on to a brief in Perkins stating that, yes, when law enforcement seizes property as evidence, they must take reasonable steps to give notice that the seizure has occurred. And so, since we're here on a motion to dismiss for failure to state a claim, I would just submit to the court that if you take 4 or 5 of the factual allegations in the complaint as true, we should have survived a motion to dismiss for failure to state a claim under the standards set forth in Perkins and Fuentes. We allege that we had a recorded security interest in these 2 motorcycles. The recording of the security interest is an issue of fact. We pled that the seizures began October 8th of 2022. We pled that there was no contact between ourselves and the appellees until December 20th of 2022. And we pled that we initiated contact. And under those circumstances, it doesn't appear that law enforcement took reasonable steps to inform us of the seizure, of either seizure.
Well, you're here at the Fourth Circuit on a simple little action that I'm flabbergasted. What is it you want?
Notice and an opportunity to be heard.
You got notice now. You know where it is. What is it you want at the end of the day after you spend another 6 months, 9 months, a year litigating this thing? What is it you want?
Your Honor, I'm out of time, but may I answer your question?
Yes, sir.
Yes.
What we want is a rule set forth for South Carolina that says law enforcement cannot wait indefinitely to give notice that a seizure has occurred. We want there to be some upper boundary of reasonableness. And we have one set forth in 5635, where persons with interest in property seized as abandoned, they're required to be given notice by law enforcement, owners and lien holders, within 25 days of seizure. That's all we want for the state of South Carolina to do for people with interest in property seized as evidence. Just give notice within a reasonable time so that people with interest in property seized as evidence aren't left to wonder where it's gone.
You want us to write a law for the state of South Carolina to do this?
No, Your Honor, we just want what other states in the Fourth Circuit have and what the court in Perkins appeared to state, that some reasonable steps must be taken to give notice.
Well, there again, I'm beginning to sound like Judge Wilkinson. Isn't that something the South Carolina legislature ought to do instead of us?
Well, if the Supreme Court has spoken on the necessity for reasonable steps, then it appears the Supreme Court has spoken, and thus it's left open to individual law enforcement officials in South Carolina to try and apply this rule in the absence of guidance from the Supreme Court. There's no requirement for a statute or a regulation to satisfy due process, but in the absence of one, I think situations like ours are bound to emerge.
The problem is that Perkins is I don't even know if you can, if it's not analogous to this case. I mean, this is a third party. Perkins, there was notice. And I think the issue there was in Perkins was not only how much notice and what details of the notice were required, because notice was given in Perkins. There was this question of, did they have to inform them of your statutory rights as to how to get the property back? And so that was, I just don't see Perkins being on point to this case. And so, Perkins, and in Fuentes, it says, you know, that they can do this if there's some valid, extraordinary, governmental interest. And here we have a murder.
Your Honor.
Yeah, you can continue.
Okay, thank you. Well, in Perkins, there was a murder as well. And yes, Perkins didn't have to address whether or not notice was given, because all the parties agreed that notice was given. But we had to track them down. We had to use social media posts to figure out that arrest of the debtor had occurred, and that the sister of the decedent contacted us to let us know that they took one of the motorcycles at some point. We had to track them down to ask if they still had it. So I think there is a similarity with Perkins in that notice is primary, that notice has to be given. Reasonable steps to give notice have to be taken.
Thank you.
Thank
Any
you.
other questions? Any other questions?
No.
Thank you. Yes, sir, Mr. Plyler.
Thank you, Your Honors, and may it please the court, Daniel Plyler, I'm here on behalf of the appellees, the appellees. This is a Fourth Amendment case and not a 14th Amendment case, and I think that's why some of the confusion and questions that are coming from the bench and that we're all trying to wrestle with here is happening, because the appellants in this case want to make this a 14th Amendment case, and it's simply not. I'd point you no further than your own precedent in Travel Peace, Smith versus Travel Peace, where this court relied on the concurrence opinion in Perkins that was issued by Judge Thomas, where they found that the Fourth Amendment was tailored explicitly for criminal justice system, has always been thought to define the process that is due for seizures of person or property in criminal cases. And that's exactly what we have here. This case is completely different than the situations in Fuentes, which was a Replevin case, if I remember correctly, or the abandoned property sort of situation that my friends on the other side referenced to you. The reason is the state interest in those type of cases is different. When we're dealing with a criminal case, as we were dealing with in the fact pattern before you, the state's interest is in preserving evidence to investigate crime and prosecute a crime. And in that situation, the Fourth Amendment has always been where this court should turn to see what process is due to anyone. Furthermore, in the West Covina case, or Perkins case as it's been called today, the court was wrestling with what happens after that need has expired. What happens when the property is no longer needed for an investigation or prosecution? And that's why Perkins is distinguishable from this case, but it also helps elicit a response that the Fourth Amendment was complied with in our case, and the Fourth Amendment is the process that's due. And again, I point you no further than Travel Peace, which this court decided in 2022 that reached that same conclusion. There's dicta in Covina, or the Perkins case, and that's not my terminology, that's actually Justice Thomas's terminology in his concurrence opinion in the Perkins case. And it seems that he was worried exactly about the situation that we're discussing here today. He was concerned that people would take the dicta in the majority opinion in Perkins and claim that you now have to give notice to anybody that might have a property interest anytime you execute a search warrant or an arrest warrant. And that simply would go against centuries of established precedent and process in the criminal justice system. It would also attempt to overlay the 14th Amendment onto the Fourth Amendment, which is something no court, well, at least no precedential court has ever held as necessary. So with it accepted that this is a Fourth Amendment case, it's easy to affirm Judge Lewis's decision, because her decision to dismiss this case, it's the last part of her opinion, excuse me, is that because the Fourth Amendment was complied with, there is no due process violation in this matter. I would like to talk a little bit about notice to the point the court's wrestling or grappling with that issue in this case. I'd start with Perkins. Perkins talks in terms of notice was provided to the owner or that notice is usually left at the area, the location where the property was seized. That did happen in this case. Notice is also, to the extent it applies in a Fourth Amendment situation, has never been required to be actual notice. It can be constructive notice. So in this situation, the appellants did receive constructive notice, one, through the sister of Mr. Brock, who is the decedent, the victim in the murder case, and then two, through the arrest warrant and the seizure of the property for Mr., and I always butcher his name, but Andrew Juski, who was the suspect in the murder. That was a search warrant that was issued. A return was, in compliance with South Carolina law, was provided to the judge that issued the search warrant, inventorying that the motorcycle was collected. Through that notice, the debtors to their contracts, their creditor contracts, were able would have been able to alert them of the fact that this is where the property is. I think it's also important to notice, and I'll point you to the Rogers case that we cite in our brief. That would be Rogers versus Knight, which is it's an Eighth Circuit opinion, but it talks about this exact issue, that it's always been held that law enforcement can take property, seize it, and hold it for criminal investigations and prosecutions. That's what happened here. You have the Serio versus Baltimore case, which is a District of Maryland case that I think delves into the issue that we're dealing with here, which is at some point in time, there may be a 14th Amendment issue, a due process issue that comes up after the property is no longer needed for investigation or arrest, prosecution of the criminal charges. And when that happens, there may be due process claims and due process issues that would trigger. But in this fact pattern that you're dealing with, you don't have to grapple with that, because as soon as the prosecutor let the Lexington County Sheriff's Department know that these motorcycles were no longer needed for their investigation or for the prosecution, the Lexington County Sheriff's Department immediately notified the appellants and told them, please come get the motorcycles. You claim that you have the possessory interest in them at this point. Please come get them. And in fact, since October of 2024, so now 12 calendar months, we've been imploring them to come get their property that they claim they want. Last point that I'd like to make, unless there's any questions from the bench, we removed this case to federal court only after they brought 1983 claims against our clients. We had a right to do so. The federal claims have been dismissed, but their claim and delivery action was remanded to state court and remains pending. So due process, excuse me, not only have they already gotten some form of process, it's still ongoing, and they have, if they, I don't know why we're having to do this, because we're offering the property back, but if they feel like they need to have a court order us to give them the property back, they have a remedy for that in state court still to this day. And Judge Floyd, I would like to touch on your qualified immunity comment, because I believe you're absolutely right. And I'd point you no further than the Moore versus County of Delaware case, which is a Second Circuit case that was decided after Crimstock, which you may have seen from some of the briefing or pleadings in this case. And in the Moore case, they actually granted qualified immunity on almost the exact same situation, speaking in terms of the dicta that's present in the Perkins case and how it didn't require the notice that particular party was seeking in a Fourth Amendment context like you're dealing with here.
So let me ask you this. If we are in agreement with you, and of course I don't know how it's gonna come out, but the simple way, from your point of view, is to just affirm Judge Lewis.
Yes, Your Honor.
You don't need any further 1983 qualified immunity attention given to it by this court.
I don't think this fact pattern is the right fact pattern to grapple with that issue if you think you need to.
Yeah.
I think the simplest thing is affirm Judge Lewis, because she's right. This was a Fourth Amendment issue, and the Fourth Amendment was complied with. And when the Fourth Amendment is complied with, that's all the process that's due. See this court's precedent in travel piece.
I understand.
Thank you.
Any other questions?
No, thank you.
Any other questions? Sorry, thank you. Yes, sir, Mrs. Studemeyer.
Briefly, Your Honor.
Yes, sir.
This is not a Fourth Amendment case, and this court's holding in Smith versus Travel Piece establishes that. If you look at footnote 6 or 7 of this court's opinion in Smith versus Travel Piece, the court cites to a case, I believe from 1870, somewhere in that range, saying that seizure is an act, not an ongoing process, that we concede, as we must, of course, that, a lawful seizure occurred in this case. The Fourth Amendment was complied with, but satisfaction of the Fourth Amendment is not satisfaction of our 14th Amendment rights. Secondly, my colleague brought up Crimstock. There are 3 Crimstock cases out of the Second Circuit that have delved into this issue extensively. Crimstock 3 in 2006 is analogous to this case. It is specifically about when property is seized as evidence in a criminal investigation. And the court in the Second Circuit, in that case, held that yes, whenever property is seized as evidence, there must be some form of hearing on the retention of that property as evidence. Crimstock 2 was on forfeiture, property seized for forfeiture, and the court held no additional hearing needs to be held there. But when property is seized as evidence, yes, there does need to be some sort of hearing. So the person.
Well, I think the Crimstock says when there's a warrantless arrest, because this was an arrest of these people that, and because I think it goes on and talks about the need for the vehicle, personal need for the vehicle, which is not the issue here because we're dealing with a third party. But I think it says warrantless arrest, and one of the, in one of the motorcycles, there was a warrant for the motorcycle, and so it wasn't a warrantless, similar to that case in the Second Circuit.
Yes, Your Honor, and one was warrantless, one was done with a warrant.
yeah.
And when we concede, as we must, that we have less of an interest in the property than someone who uses it daily for transportation. We're a secured creditor, we're not normally in possession of the collateral, but we do have some interest. And Fuentes establishes that whenever there's any significant property interest, something less than undisputed ownership, due process is implicated. So I think the holding in Crimstock 3 is analogous here. And to Judge Floyd's earlier question on what do we really want, one of the other issues is the depreciation of the motorcycles, that we have 2 interests in the property. We have contractual right to repayment of the debt that's owed by the debtor, and we have a property interest in the property in the event of default. Well, our position is that in the gap between when the motorcycles were seized after some reasonable period, and then when we are finally given an opportunity to be heard by a neutral fact finder on their retention, the motorcycles are depreciating, and we have not been afforded process.
How in the world are you gonna get that out of the government? How in the world are you gonna collect appreciation from the government? How does the government owe you appreciation for your motorcycles
Well,
that they lawfully seize?
Well, yeah, we don't dispute the lawfulness of the seizure. What we dispute is the lawfulness of the retention until we're told about it and have an opportunity to be heard. That we are not entitled to any notice prior to seizure. We're not entitled to notice at the time of seizure. We understand that things have to be inventoried, that a return has to be made on a warrant within 10 days. We think that there is some reasonable time after seizure where beyond that, if notice is no longer, is not given, then it's unreasonable to hold property that's depreciating, rusting, that's having weeds grow up between its spokes, and suffer that kind of injury.
Well, I don't know, I think was it United States versus it's 8,850, the Supreme Court said 18 months was not an unreasonable delay.
Yes, Your Honor.
And we're at 24 months, right?
And I'm not familiar with that case specifically. My analysis of reasonableness was based on analogous South Carolina statute, but I take the court's word for it on that Supreme Court case. If there are no further questions from the court, then we rest on our brief.
All right. Thank you.
Thank you.
All right, we'll step down and shake your hands, and if you all can come up and shake Judge Floyd's hand.